Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. We begin with news out of Wisconsin, where a Waukesha judge once again ordered defendant Darrell Brooks out of the courtroom after she says he's making a mockery of court proceedings. Brooks faces 77 charges stemming from the deadly Waukesha parade crash last November. 6 people were killed and dozens more are injured when prosecutors say Brooks rammed his SUV into the annual holiday parade. Brooks has made national headlines since then after moving to represent himself in the trial, claiming to be a sovereign citizen. Presiding Judge Jennifer Darrell has called for his removal from the courtroom multiple times, noting he interrupted proceedings on Thursday within the first minutes of court. When Brooks was again ordered out of the courtroom, he removed his shirt. Judge Darrell noted he also took off his shoe and was aggressive with court deputies. Brooks' actions have called into question his mental competency, but prosecutors believe it's an act of defiance.
These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on.
Judge Darrell backed prosecutors, saying multiple competency exams have already been performed, arguing his actions are a conscious decision to interrupt proceedings.
This court has read through not 1, not 2, not 3, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. It is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue.
Joining us today is legal analyst Matthew Mangino and co-host Terry Austin. Matthew, you can't tell me that it won't be at least argued that a shirtless Brooks isn't competent to stand trial. Is there any way this case doesn't get wrapped up in appeal after appeal?
Well, Brian, I don't see any way around it. I mean, this case is certainly going to be one that's going to be scrutinized by an appellate court. I think that the judge is doing the best that she can to keep control of her courtroom. But you have what appears to be a defendant who's defiant, a defendant who doesn't want to follow the decorum of the court, a defendant who wants to be disruptive, who wants to make a point. I mean, it lends itself by his very conduct, taking off his shirt, turning his back to the court, that, is he competent? Can his competency change from an evaluation that was done in the past to the current time? I mean, these are all issues this court has to deal with.
Yeah, and of course, I think we got a correction. His name is Darrell Brooks. He's asked the judge to pronounce it that way. But Terry, what do you think the jury is thinking about this at this point, about Brooks and about the process of criminal trial in general?
The whole trial, at least for when the jury came in, began with him in that adjacent courtroom. So the first thing they're probably thinking is, why is he in another room? Why is he wearing a jail uniform? And the judge was very careful not to say that he was disruptive, but she did in her jury instructions. She stated that when you have someone who is disruptive, they can, obviously deal with that as far as the court's concerned. And then she mentioned, well, Brooks is in the other room. So I think they can come to that conclusion that he's being disruptive and he's not following the rules of the court.
Yeah, and they'll probably see it as this case continues, that disruption that he's putting forward in front of the court. Probably not going to help his case. Well, still ahead on Law and Crime Daily, we continue our complete coverage in the Waukesha Parade massacre trial. The judge allows Brooks back inside the courtroom, but not without an argument. See the pair clash once again after the break. Welcome back. After an eventful morning in the Waukesha Parade crash trial, Judge Jennifer Darrell gave Brooks the opportunity to return to the courtroom for the afternoon reading of jury instructions. Again, Brooks refused to stop when Judge Darrell instructed him not to interrupt. She said his actions are a stalling tactic.
If you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
The ongoing argument continued even as jurors were brought into the courtroom.
I still would like to ask
Mr.
questions,
Brooks,
Your Honor.
stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr. Brooks,
you have
the
not
jury
shown.
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It is my right.
Mr.
I'm
Brooks,
merely
you can
exercising my right.
stand, you need to be quiet.
Opening statements finally began late Thursday afternoon. We'll break down what happened on the next episode of Law and Crime Daily. Terry, what options does the judge have when dealing with a disorderly defendant, and why did she allow Brooks back into court?
You know, that's a great question. Under Wisconsin law, she has several options for someone who is, quote, stubbornly defiant. And he was stubbornly defiant. He is still competent as far as we're concerned, but she can hold him in contempt. She specifically said she did not want to do that. She wanted to give him an opportunity to be in there, and she gave him every opportunity. And I absolutely think when that jury came in, when they saw how he was behaving, if they had some question before as to why he was in another room, it was clear to them because he was disrupting every part of the process. She allowed him to come back because one of the things she said was, listen, if you can promise you will abide by the rules and you will be considerate, then you can come back in. So every part of the process, she's giving him that opportunity. She said, come back in for the rest of these jury instructions. But as you saw, he still is not listening. So she's trying to do her best not to be reversed on appeal.
Yeah, I mean, that seems like the goal here. Matt, is there logic behind this chaos? Is Brooks just looking for a mistrial, or is this just a man that clearly cannot represent himself?
Well, you know, I think, I mean, if there was logic behind this, he'd be trying to present some cogent defense on his own behalf, or even better, he'd have representation of legal counsel, competent legal counsel. I'm not sure what the end game here is for Brooks. It's just delay. You know, so if he can prolong this process, if maybe he can get a mistrial, if he can get some sort of delay, it's just putting off what's ultimately going to happen here. You know, he's not going to walk out of this courtroom without there being a verdict. You know, unless that verdict is not guilty. And I think that's extremely unlikely. He probably thinks it's extremely unlikely. And that's why he's in this process of just trying to be disruptive, trying to get to delay. And it really, I don't see as having any real logic behind it other than I'm facing a lot of time and I'm just going to do whatever I want to do in this courtroom.
Yeah, and don't forget, he's starting to do this in front of the jury, not the smartest of moves. Well, switching to the West Coast, a California family is found dead after going missing earlier this week. A manhunt ensued after the family of four, including an 8-month-old, her mother, her father, and her uncle, disappeared Monday morning. A few hours later, one of the family members' vehicle was found ablaze. That led law enforcement to determine the family was kidnapped and forcibly taken at gunpoint from their own trucking business. Authorities announced late Wednesday the bodies of the child and 3 adults were found dead in an orchard. 48-year-old Jesus Manuel Salgado, who has a criminal history, was taken into custody Tuesday. Police say he attempted suicide before his arrest and was hospitalized in critical condition. They say other suspects may have also been involved. Officials believe the crime may have been financially motivated. Coming up on Law and Crime Daily, closing arguments are presented in Alex Jones's second Sandy Hook defamation trial. Plus, the Parkland school shooter penalty phase trial. A rebuttal witness refutes the defense's narrative, but will that be enough to sway the jury?